Hello everyone, welcome to your constitutional law series and in this particular lecture we'll be covering Article 16. So अगर आप Article 16 पढ़ेंगे, it is further divided into 6 clauses. We'll be looking at some of the fundamental case laws which have affected Article 16 over the period of time, and we'll be looking at some of the recent case laws जो Article 16 को interpret करते हैं. So let's get started with the video. So, the Article 16 of the Indian Constitution talks about equality of opportunity in public employment. Clause 1 states that equality of opportunity for all citizens in employment or appointment to any office under the state. And this is applicable only to citizens and not to non-citizens. Also, जब आप clause 1 पढ़ेंगे, it talks about equality. So what kind of equality are we talking over here? We are talking about equality between members of same class of employees, not members of separate or independent classes. So जब हम equality की बात करेंगे, we mean the people belonging to the same category. Now, if you read clause 2, it states that no citizen shall, on the ground only of religion, race, caste, sex, descent, place of birth, residence or any of them be ineligible for or discriminated against any employment or office under the state. So, अब आपका clause 2 क्या provide करता है? Clause 2 provide करता है कि कोई भी citizen को आप इन grounds पे discriminate नहीं करेंगे while you're considering them for an employment or an office under the state. So, जब हमने अपना Article 15 पढ़ा था, it talked about 5 grounds of discrimination that are the religion, race, caste, sex and place of birth. Article 16, remember, आपके 2 additional grounds provide करता है discrimination prohibit करने के लिए, which are descent and residence. Now, why residence? When I talk about India, India has a common citizenship. हर एक state की अपनी citizenship नहीं है. When you're a citizen of the entire country. So, अगर हम common citizenship में believe करते हैं, how can we prescribe residence as a factor for discrimination in case of public employment? So, that is the reason we have added residence as a factor not to discriminate. So, अगर आप अपना second word देखेंगे जो कि है descent, ये prohibit करता है employment based on hereditary principles. So, कोई भी person कि सेम फैमिली मेंबर्स को आप अपॉइंट नहीं करेंगे जस्ट बिकॉज दे बिलोंग टू अ सर्टेन कैटेगरी or they belong to a certain person's family. So that is also prohibited when you're considering the person for public employment. Now one of the important case laws जो आपके 16 clause 1 को explain करता है वो है Union of India versus SC Bagari. ये बात करता है कि how in case of differentiating factors provided to army officers will still be valid. So the army officers are distinguished on the basis of commissioned and non-commissioned officers. So इसके differentiation में उनको different grant दी गई थी study leave. Supreme Court held that such differentiation is not violative of clause 1 since these are not situated in similar circumstances. Army officers के केस में काफी classifications होती हैं. So if you are differentiating between two officers which are not in the similar circumstances, let's say एक commissioned officer है and एक non-commissioned officers हैं, then that is a valid point of differentiation and will not violate our clause 1. Another important factor जो आपको clause 1 के interpretation में note करना है, that is when I'm talking about equality guaranteed by 16 clause 1, it takes within its fold all stages of services. कोर्ट ने ये इंटरप्रेट किया है यहाँ पे कि जो इक्वालिटी की बात की गई है क्लॉज 1 में, दैट टेक्स विद इन इट्स फोल्ड ऑल स्टेजेस ऑफ सर्विसेज. द प्रोविजंस और द matters which are subsequent to the employment यानी कि salary, periodic increments, leave, promotion, इसमें भी you cannot discriminate between citizens when you're talking about office under the state. So the equality includes it within its fold all the stages of services, that is pre-employment and post-employment as well. Now after understanding the general rule, we move on to the exceptions to the general rule. I want you to understand one particular factor or one particular concept जिसके बारे में आपके दिमाग में doubt भी आ सकता है, that is compassionate appointment. So अगर किसी गवर्नमेंट सर्वेंट की ऑन ड्यूटी या इन सर्विंग द गवर्नमेंट डेथ हो जाती है, you may often have observed the government provides jobs or employment or appointment within the government machinery itself to the son, daughter or widow of such a family to relieve the economic stress. So compassionate employment का ground होता है interest of justice, and court ने कहा है compassionate appointment is provided after examining the financial conditions of the family. In case of compassionate appointment, it is valid under 16 clause 1 and 2 and ये उसको violate नहीं करेगा. Now if you read clause 3, Parliament may provide for residence as a condition for certain employment in state or union territory or local authority or any other authority. Now clause 3 क्या provide करता है? Clause 3 ये provide करता है कि Parliament residence as a condition provide कर सकता है for certain employment in the state, union territory, local authority or any other authority. यहाँ पे ये पावर सिर्फ पार्लियामेंट को दी गई है. Now we'll understand clause 5 first and then we'll move on to clause 4, because clause 4 is an elaborate provision and we need to understand all the components and some of the key case laws in that. So we'll first finish clause 5. So ये बात करता है कि nothing in the article 16 shall affect the operation of any law. अगर कोई law बनाया गया है which provide that holder of an office in connection of affairs of religious or denominational institution उसी religion या particular denomination को belong करेगा, तो ऐसा कोई भी law आपका article 16 को violate नहीं करेगा. This is just to safeguard the operation of religious or denominational institutions. Now we need to understand one of the most important clauses in your Article 16 and one of the most important exceptions which further has 16.4a and 16.4b. So clause 4 talks about state may provide for reservations of appointments or posts in favor of any backward classes of citizens which in opinion of state is not adequately represented in the सर्विसेज अंडर द स्टेट. सिंपल टर्म्स में क्लॉज 4 ये बताता है कि स्टेट स्पेशल प्रोविजंस बना सकता है फॉर द रिजर्वेशन ऑफ अपॉइंटमेंट्स और पोस्ट फॉर बैकवर्ड क्लासेस जो कि स्टेट की ओपिनियन में एडिक्वेटली रिप्रेजेंटेड नहीं है इन सर्विसेज अंडर द स्टेट. ऑल्सो व्हेन वी टॉक अबाउट एडिक्वेटली रिप्रेजेंटेड, व्हाट डू वी मीन? वी मीन न्यूमेरिकल प्लस क्वालिटेटिव टेस्ट. इसका मतलब क्या है? जब हम ये बात करते हैं कि स्टेट विल बी चेकिंग whether a backward class is adequately represented or not, वो दो फैक्टर्स को देखेंगे. फर्स्ट फैक्टर कि उसकी न्यूमेरिकल यानी कि उसकी नंबर्स ऑफ रिप्रेजेंटेशन कितनी है, हाउ adequately are they numerically represented. Second, qualitative test, that means state ये भी देखेगा what kind of positions do they actually hold. Do they hold positions of importance? On what position a person of backward class is there? Means हमें numerically भी देखना है, and when we are talking about adequate representation, then also we need to see on which post the person from the backward class are most appointed. So both the considerations will be seen by the state in terms of considering the adequately represented factor. So अब आपके आते हैं 16.4a पे, जो कि बहुत ही important provision है which was added in your constitution by the 77th Amendment Act 1995. So ये basically बात करता है nothing in the article shall prevent the state from making any provisions for the reservation in matters of promotion. Also please add with consequential seniority to any class or classes of posts in services under the state in favor of scheduled castes and scheduled tribes which in the opinion of state are not adequately represented. And the principle of consequential seniority was added in 85th Amendment Act 2001. So अब important factors जो आपको remember करनी चाहिए while you're reading 4A are, Firstly, it's available only to scheduled castes and scheduled tribes and not to other backward classes. And next, जब हम 4A पढ़ेंगे, we are talking about two things. First is the matter of promotion and second, consequential seniority. So अब consequential seniority एक concept जो आपको समझना बहुत important है. Let's say दो candidates हैं A and B. So your A candidate is from a scheduled caste and your B candidate is a general category person. So state ऐसे provisions बना सकता है जो A को B से पहले प्रमोट कर दे because he or she is a reserve category candidate. Not only ऐसे provisions बन सकते हैं जो A को B से पहले प्रमोट कर दे, but A can retain seniority. That is what we understand by the term consequential seniority. So, Supreme Court of India upheld the constitutionality of reservation at promotional level in the case of General Manager Southern Railway Personnel Officer Reservation versus Rangachari. So, इस particular case में Supreme Court ने ये कहा था कि reservation सिर्फ appointment और employment लेवल पे नहीं, प्रमोशनल लेवल पे भी आप मेंटेन करेंगे. बट वन ऑफ द लैंडमार्क जजमेंट्स जो कि है इंदिरा सावनी वर्सेस यूनियन ऑफ इंडिया डिक्लेयर्ड दिस पर्टिकुलर थिंग एज अनकॉन्स्टिट्यूशनल. इस केस में सुप्रीम कोर्ट ने कहा था कि रेजर्वेशन शुड बी लिमिटेड ओनली टू द इनिशियल अपॉइंटमेंट और एम्प्लॉयमेंट ऑफ सर्विसेज अंडर द स्टेट. मतलब अब रेजर्वेशन सिर्फ इनिशियल केसेस में बनाएंगे एम्प्लॉयमेंट में, promotion में reservation नहीं होगी and every candidate should be treated the same. However, this was undone when constitutional amendment was made, that is the 77th Constitutional Amendment Act 1995. 16(4)(a) की development we have discussed in this particular slide. And जब हम बात करेंगे consequential seniority की, this was added by the 85th Amendment Act 2001. Now let's move on further and understand what is 16(4)(b). So, आपका Article 16(4)(b) was added by the Constitution's 81st Amendment Act 2000. So this talks about the carry forward rule. So ये basically बात करता है that the unfilled reserved vacancies are to be carried forward to subsequent years and these vacancies are to be treated as distinct and separate from the current vacancies of any year. That means अगर कोई भी unfilled reserved vacancy है आप उसको next year तक carry forward कर सकते हैं. 4B talks about your carry forward rule. Further, it states that 50% reservation applies to normal vacancies and not to posts of backlog. So, कोर्ट ने ये कहा है जब आप 50% reservation max ceiling limit की रूल की बात करते हैं that the overall reservation for the reserve candidate should not be more than 50%. इसमें आप posts of backlog को include नहीं करेंगे because they are treated as distinct and separate from the current vacancies of the year. And the unfilled reserve vacancies are filled separately from the normal vacancies. So now we'll move on to your clause 6. So your clause 6 of Article 16 talks about that nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favor of economically weaker sections of citizens, subject to a maximum limit of 10%. So इस particular provision में state ये कहता है कि in addition to the existing reservation and other than the classes mentioned in clause 4, आप इकोनॉमिकली वीकर सेक्शन के लिए रिजर्वेशन कर सकते हैं मैक्सिमम ऑफ 10% इन केस ऑफ अपॉइंटमेंट्स और पोस्ट्स. नाउ लेट्स मूव ऑन टू अ वेरी इंपॉर्टेंट फैक्टर ऑफ योर लेक्चर, that is your case laws. Now while reading your Article 16, it is very important that you read certain cases. सो फर्स्ट केस आता है आपका इंदिरा सावनी वर्सेस यूनियन ऑफ इंडिया, जो कि एक बहुत लैंडमार्क केस है व्हेन यू आर टॉकिंग अबाउट आर्टिकल 16. इसमें सुप्रीम कोर्ट ने ये कहा कि reservations provided under 16 clause 4 should not exceed 50%. Broadly, the questions framed in this particular case were whether 16(4) is an exception to Article 16 clause 1, what is the definition of the term backward classes. Further, court talked about the reservations of appointments or post in favor of backward classes should be restricted to the initial appointment or post. That means जो reservations हैं आप उन्हें promotions में नहीं extend करेंगे. ये हम already discuss कर चुके हैं. This has been changed by the constitutional amendment itself. Also, कोर्ट ने ये कहा कि economic cannot be the sole criteria to determine the backward classes. Further, court observed that Article 16 Clause 4 is an exhaustive provision. That means the expression of the term backward class includes caste, occupation, poverty, place of residence and lack of education. मतलब जब भी हम backward classes की बात करेंगे जो आपके 16 Clause 4 में यूज हुआ है वो एक holistic term है जिसमें caste एक sole factor नहीं है, various other factors are also there. Now, next important case that you must read is Ajit, Singh, Januja and Union of India versus Virpal Singh. So, इन केसेस में सुप्रीम कोर्ट ने इंटरप्रेट किया है कैचअप रूल और इन केसेस में सुप्रीम कोर्ट ने ये कहा दैट कॉन्सिक्वेंशियल सीनियरिटी नहीं एप्लीकेबल होगी, रादर कैचअप रूल विल बी एप्लीकेबल. एंड इसमें कोर्ट ने ये भी कहा कि consequential seniority on promotional post is not covered by Article 16(4)(a). So, सुप्रीम कोर्ट ने जहां की इन दोनों केस में ये कहा कि consequential seniority एक प्रिंसिपल नहीं है जब आप reservation कंसिडर कर रहे हैं and the general category candidate can very well regain this seniority, ये प्रिंसिपल चेंज हो गया विद 85th Constitutional Amendment Act जिसने कैचअप रूल को रिपील कर दिया है. Now another very important judgment that you must read is M. Nagaraj versus Union of India. इस पर्टिकुलर केस में सुप्रीम कोर्ट ने ये कहा दिस सीलिंग लिमिट ऑफ 50%, concept of creamy layer and compelling reasons जो हैं are all constitutional requirements without which the structure of equality will collapse. सुप्रीम कोर्ट ने कहा कि 50% सीलिंग लिमिट ऑन रिजर्वेशंस होनी चाहिए, क्रीमी लेयर का प्रिंसिपल एप्लीकेबल होना चाहिए, अदरवाइज द प्रिंसिपल्स ऑफ इक्वालिटी मे कोलैप्स. एंड एम नागराज वर्सेस यूनियन ऑफ इंडिया में पिटिशनर ने चैलेंज की थी 77th, 81st, 82nd and 85th Amendment Act before the Supreme Court. The 5-judge bench upheld the constitutional validity of the reservation in promotion of scheduled caste and scheduled tribe. Also, court noted that 16A and B are enabling provisions. And court ने कहा कि for reservation to be valid, state has to meet 3 compelling reasons. First, the state has to demonstrate backwardness of scheduled caste and scheduled tribes. Second, state should prove inadequate representation in public employment. Third, state should ensure maintaining overall efficiency of administration. So ये 3 ब्रॉड प्रिंसिपल्स दिए सुप्रीम कोर्ट ने कि जब भी आप रिजर्वेशंस प्रोवाइड करेंगे बैकवर्ड क्लासेस के लिए यू नीड टू कंसिडर दीज क्राइटेरियाज. अब इस केस के बाद जो 3 कंडीशंस इंट्रोड्यूस की थी मेड इट वेरी डिफिकल्ट टू एडवांस प्रमोशन पॉलिसीज. So the 3 conditions that were mainly to prove the backwardness, to prove the inadequacy of representation and to prove the overall administration efficiency, इससे बहुत डिफिकल्ट हो गया रिजर्वेशंस प्रोवाइड करना बैकवर्ड क्लासेस को. सो अब आया आपका जर्नैल सिंह वर्सेस लक्ष्मी नारायण गुप्ता केस 2018. So this particular case broadly agreed with M. Nagaraja versus Union of India. However, it struck down the demonstration of further backwardness criteria from Nagaraja case. So court ने पहला criteria हटा दिया कि state को ये proof करना होगा कि classes are backward in cases of providing reservations. जर्नैल सिंह के केस में कोर्ट also held that principle of creamy layer exclusion extends to scheduled caste and scheduled tribe. So कोर्ट ने ये भी कहा कि once the scheduled caste and scheduled tribe are shown in the list of articles 341 and 342, there is no question of showing backwardness. So जो पहला criteria M. Nagaraj versus Union of India ने state किया था उसको स्ट्रक डाउन कर दिया जर्नैल सिंह वर्सेस लक्ष्मी नारायण गुप्ता ने. अब आपका लास्ट इंपॉर्टेंट केस दैट वील बी डिस्कसिंग इज बीके पवित्रा वर्सेस यूनियन ऑफ इंडिया. सो 2019 के जजमेंट में क्या हुआ था the 2018 Karnataka Reservation Act was challenged that introduced consequential seniority for scheduled caste and scheduled tribes in state government services that enables the reserved category candidate to retain their seniority for subsequent promotion. So हम already discuss कर चुके हैं, ये कहाँ पे stated है आपका 16(4)(a) में. Remember दो principles हैं 4A में that are promotion as well as consequential seniority. So इस पर्टिकुलर केस में सुप्रीम कोर्ट ने अपहेल्ड करी थी कॉन्स्टिट्यूशनल वैलिडिटी ऑफ द 2018 कर्नाटका रिजर्वेशंस एक्ट. ऑल्सो कोर्ट ने ये कहा कॉन्सेप्ट ऑफ क्रीमी लेयर हैज नो एप्लीकेशन इन ग्रांट ऑफ कॉन्सिक्वेंशियल सीनियरिटी. And lastly, court stated that reservation is a valid exercise of power conferred by 16(4)(a). So अब आते हैं आपकी last slide पे, which is revise, repeat and remember. Now let us together recall what does each clause of Article 16 state. आपका clause 1 क्या बताता है? It states that there shall be equality of opportunity for all citizens in matters related to employment as well as appointment. Basically बात करता है कि सब equal होंगे when you're considering employment or appointment to post under the state. Clause 2 क्या बताता है कि आप किसी भी citizen को on the grounds of religion, race, caste, sex, descent, place of birth or residence ineligible नहीं कर देंगे या discriminate नहीं करेंगे in case of any employment or office under the state. So basically ये 5 grounds include करता है Article 15 के plus additional 2 grounds which are descent and residence. Clause 3 talks about residence may be prescribed by the parliament as one of the factors within that state or union territory prior to such employment or appointment. अब आपका clause 4 क्या बात करता है? It talks about reservation for backward classes not adequately represented in the services under the state. इसी से emerge होते हैं आपके 4A and 4B. 4A talks about principles that reservation can also be extended to promotion as well as consequential seniority in cases of scheduled caste and scheduled tribes. 4B बात करता है carry forward rule की. Please remember 4B talks about carry forward rule. That means in case of any unfilled reserved category seats, these will be carried forward to the next year and will be filled next year and 50% maximum ceiling limit इस पे applicable नहीं होगी. Clause 5 talks about religious and denominational institutions and lastly clause 6 talks about your economically weaker sections. So I hope you are clear with Article 16 in a holistic manner. We discussed the basic concepts. We discussed the development of various clauses and various amendments in this particular article. I know this particular article can get a little bit confusing क्योंकि इसमें काफ़ी सारे amendments है Constitution की and काफ़ी सारी keys laws की developments हैं. Please just understand and if there's any doubt, do let me know in the comment section down below. Apart from that, any suggestions you can also let me know in the comment section down below. So, thank you so much for watching and do click the subscribe button so that you are notified when I upload a video every Tuesday and Saturday. And हम अपने next lesson में cover करेंगे some of the other important fundamental rights and after that we'll be moving towards other components of your constitutional law. Till then, stay home, stay safe and keep learning.